Kristen McMahon, and I have the pleasure of serving as the president of the Robert H. Jackson Center in Jamestown, New York. We envision a world where the universal principles of equality, fairness, and justice prevail. So Jackson Day in Warren was the last in-person event we did in 2020. And I am an avid reader. I love books. I love bookends. And so it seems very fitting that our first return to in-person programming is also Jackson Day in Warren this year. So thank you all very much for being with us this evening. Our 2022 programming theme is Democracy on Trial. And we're looking at the challenges to, pressures on, and opportunities for democracy and democratic institutions, both in the United States and around the world. And I am excited to explore these topics because I am every bit as much a student as you all are. This is not my area of expertise. I sometimes read a chapter or two ahead so I know what questions to ask, but this is very much a learning exercise for me too. And tonight, clearly, we will be taking a look at executive power and one of Justice Jackson's favorite concepts, liberty under law. Tonight, we are commemorating the 70th anniversary of an opinion written by Justice Jackson, one of 7 actually written in the Seizure case. You are going to hear about opinion measuring, which is a term I have come to love. And for those who watch the US Supreme Court, we know that it's not just the immediate votes that count. It is also how opinions live on in the world. To quote a favorite West Wing episode of mine, and if you know me, you know I'm addicted to that TV series. Who writes the extraordinary dissent? The one man of majority opinion whose time hasn't come, but 20 years later, some circuit court clerk digs it up at 3 a.m. Or in our particular case, change dissenting opinion to concurring opinion, and you have Robert H. Jackson. I'd like to thank our sponsors for tonight's event, the Samuel Bonavita Endowment Fund, Allegheny College, and United Refining, as well as all of our donors. We are so grateful for your continued support and that you bring us to new audiences. The Jackson Center offers all of its programs for free, and we rely on the support of our donors to enable us to do this. So I am happy to speak with you more about how you can support our mission and work, but I certainly want to say thank you for doing so. And while it should stop surprising me, I once again learned how many roads lead to or from Robert H. Jackson, but I'll let our speaker elaborate on that more during his talk. And with that teaser, I am quite pleased to introduce tonight's keynote speaker. Matthew Steilen is a professor of law and an affiliated faculty member in the Department of Philosophy, College of Arts and Sciences at the University of Buffalo. He holds a JD from Stanford Law School and a PhD in philosophy from Northwestern University, which makes him one of the rare lawyers you can actually address as doctor as well. He teaches and writes in the areas of constitutional law and legal history. At UB, he has taught constitutional law, federal courts, administrative law, complex litigation, and civil procedure, as well as seminars on administrative history and the history of common law. His central research interest is the development of legal institutions and ideas, which also makes him pretty perfect for tonight. His articles have examined judicial review, due process, royal prerogative, presidential powers of non-enforcement, constitutional conventions, and many others. My first experience hearing Professor Steilen present was at the James Otis Lecture at a Constitution Day program the Jackson Center does in partnership with the Buffalo chapter of the American Board of Trial Advocates. And that was held at the Robert H. Jackson Federal Courthouse. You are in for a real treat this evening, so please help me welcome Professor Steilen.
Thank you. All right, can everyone hear me? I'm going to stand back here so the people on the right side of the room can see the slides. My habit is to wander around as I lecture, so maybe just make a motion if I stand in front of the images. I'll do my best to give you a view. I'm so pleased to be here on the bookend, your return to face-to-face programming for the Jackson Center. This semester was my return to face-to-face teaching in big classes, and it's so energizing to be able to interact with people in the flesh, isn't it? Zoom is a great tool. It's a great way of reaching people that you couldn't reach otherwise, but as a teacher, there's really nothing like being in person. I'm really excited for the Jackson Center. It sounds like you have a lot of great programming coming your way. You're really lucky to have this institution, and I'm so pleased that Kristen asked me to talk tonight. Here's where I want to start. You want to know who this guy is? It's not our man, right?
Earl Warren.
No, not Earl Warren.
Stone.
Nope, not Stone. Wrong. Who is it? It's Vinson. Very good, Greg. Chief Justice Vinson. Why would I begin a talk on the Steele seizure case with Chief Justice Vinson? Vinson lost the case. He wrote the dissent. The vote breakdown was 6 votes in favor of the majority opinion to 3 votes against. Vinson was joined by 2 colleagues. Why start with Vinson? Well, even though Vinson lost the case, his opinion articulated what was a very important idea, and that idea you see described here. Let me read it for you in case you can't see the text. The title of this article in the Yale Law Journal from 2006 is "The President's Completion Power." 2 very high-flying scholars there, Jack Goldsmith, the professor at Harvard, John Manning, the dean of the Harvard Law School. What's the president's completion power? It's a power the president has to carry out a legislative scheme, filling in the details even where Congress has not. Goldsmith and Manning tell us the most authoritative exposition of the completion power, which they think is part of our constitutional law. Where does it come from? It comes from this guy's dissent. It comes from his losing opinion. This is an example of what I call the afterlife of a case. The life of a case is what the judge sets down. It's the opinion of the court that receives the most votes in cases where there is a panel. And it is the reasoning that the court uses to justify its judgment or order. The afterlife of a case is not what the court sets down, it's what other people off the court take up. It's how they find uses for what the judges have said. And it's not something the court can do for itself. You may recall that the year after the election of President Biden, one of the big topics of discussion was reforming the Supreme Court. Do you remember this? There was talk of adding seats to the Supreme Court, trimming its jurisdiction, limiting its power. People were worried about the authority that a court had to impose its will on a country. It felt non-democratic. Well, the afterlife of a case is a way in which what the court does can be the basis of popular action. Because it's people off the court, lawyers in other branches, lawyers in state government, you and me here, making use of opinions that gives them the authority that they have in their afterlife. That's a popular authority rather than the authority of the court. It's the perfect thing to talk about when we're talking about Jackson. Here he is in 1952 with George Niebank, who's a Buffalo lawyer, grad of the University at Buffalo, and I think he was to the Jackson Center at one point. Jackson's clerk, the term, one of Jackson's clerks, I believe the term that the Steele seizure case was decided. This opinion is a great opinion for studying the afterlife of a case. Why? Well, as Kristen mentioned, when it left the justice's pen, it was one of 7 opinions in the case. It had exactly 1 vote behind it, his vote. Okay? It was just 1 child in a really large family. And it wasn't the firstborn, the opinion of the court, authored by Justice Black. It wasn't the bad boy, the dissent from Chief Justice Vinson. Yet today, it is definitively the opinion associated with the case. So it's a perfect case study for trying to understand how it is that opinions can be taken up and made use of, and their authoritative status change over time, regardless of what the Supreme Court does, but because of what people off the court do. Okay? I'm going to have two parts to my talk today. Some of the text doesn't show up quite large enough, so I'll just read it. The first part is going to be life. I'm going to talk a little bit about the context of the case, the factual background, the state of the doctrine when the justices had to decide it, and then just a brief primer on the different opinions in the case. That's the life. And then part two will be afterlife. I'm going to take a brief look at how Justice Jackson's opinion was used in an effort to explore a theory about how it came to have the status that it enjoys today. So that's what's on the menu, all right? Okay, so let's start with the factual background in the case. I don't know how well you can see this. It's a graphic from the New York Times published in April of 1952, right around the time of the seizure. What it depicts is the steel-making complex. There's a large ring around what was then the steel belt, what they now call the rust belt, which was producing at the time about 40% of the steel used in the world. Around this time, we had the war or police action, as it legally was described, in Korea, which created a lot of demand for steel. An increased demand for steel led to what we're experiencing now, which is inflation, price inflation. The government responded to the price inflation that was affecting the steel industry the way that New Deal era government typically worked, by imposing price controls. And so the steel industry could only charge a certain amount for the steel it was selling. Around the same time, the contract of the major steel workers union was up, and the union signaled that it wanted to negotiate for increased wages and benefits. Management was actually pretty happy about this, because what they thought was the demand for increased wages would give them leverage to demand increased prices from the government. Okay? And that is what happened. This dispute was brought to the government. There were regulatory agencies that tried to resolve the labor dispute. The Office of Wage Stabilization was one of them. They worked on the dispute. They proposed both an increase in wages for the steel laborers and an increase in prices for the steel manufacturers. But the price increase proposed by the government agencies wasn't large enough. Okay? And the management refused the deal that was suggested. There was something that the government could do beyond this. The Taft-Hartley Act, which was the relevant regulation of labor disputes, allowed the government to petition a federal court for an injunction stopping a strike. But instead, they followed a different path, and you know what they did. They seized the steel mills. Now, there was a lot of precedent for this. In World War II, Roosevelt had repeatedly seized industries, firms that were involved in manufacturing war materials. And in fact, in 1941, then Attorney General Robert Jackson authored an opinion in support of President Roosevelt's seizure of a factory in California making planes. In that case, I believe, Jackson argued that there were communists that had infiltrated the laborers and were trying to scuttle negotiations. And so the president, according to Jackson, could rely on the aggregate of his powers under the Constitution and even his commander-in-chief power to put down an insurrection. Okay? So there was precedent for seizing mills in order, or seizing manufacturers of war materials in order to stop a strike. They did this, though, and there was a huge backlash. Here's New York Times coverage from right after the seizure. You can see right here that the president gave an address in which he blamed the seizure on the management. He said they were trying to extort on the labor crisis to get higher prices. They were motivated by greed. But the public was instantly critical of it. People didn't see the emergency that Truman and his advisors saw. They didn't have a sense of the same kinds of war exigency that had existed during the Roosevelt administration and justified Roosevelt's seizures of the plants. There was no broad public sense, according to the legal historian Maeva Marcus, who's written what is still the most authoritative book on this. There was no public sense that there was a shortage of steel. What it really looked like the president was doing was essentially ignoring the Taft-Hartley Act set out by Congress, which provided a mechanism for resolving labor disputes and confiscating private property on his own. So it was immensely unpopular. The very day after the seizure, this says the litigation, for those of you in the back row, the very day after the seizure, the steel man, actually they showed up that night, but the day after the seizure, litigation began. The management was seeking an injunction to stop the Secretary of Commerce from seizing the steel mills. And government showed up to defend the order from President Truman that the Secretary of Commerce take possession of the steel mills. The whole litigation was conducted in the shadow of public condemnation of the seizure. Another legal historian who's worked on this, Patricia Belia, who's at Notre Dame, found out that the government briefs in this litigation, the government lawyers basically cut and pasted their arguments from an earlier seizure conducted under Roosevelt. And so those cut and pasted arguments were all based on war. Okay? That was the immediate context in the Roosevelt seizures. But this wasn't a war context. And the district judge, reading the papers of the government, got involved in a colloquy with the government attorney, a guy by the name of Baldridge, in which he tried to press the government attorney on what the limits of the president's seizure power was. We're not actually technically at war. The colloquy was disastrous for the government. At the end of the day, Attorney Baldridge basically said that President Truman had a power to do whatever was necessary to resolve an emergency, and that he was the only one who could decide there was an emergency. The press covered this, and when it reached the newspapers the next day, people were livid. So by the time the case reached the Supreme Court, a month later, it wasn't really understood broadly to be about war. It wasn't really even understood, essentially, to be a labor dispute. It was about the power of the president to ignore a statute passed by Congress, the Taft-Hartley Act, which provided a mechanism for resolving labor disputes of this nature, and seize private property himself. It was about Article 1 versus Article 2, Congress versus president. There you have all the members of the Vinson Court. I'll test you later on whether you can name every single one of them, okay? Our hometown hero is, if you can tell over here, standing right next to Justice Frankfurter and Justice Clark. And I'm going to point out some comparisons to Frankfurter as we move forward. So that was the context in which the Vinson Court received this dispute. What was the state of the legal doctrine? What resources did they have for resolving a dispute, which they perceived to be, in essence, a dispute between Congress and the president? I don't have any way of seeing my time. Okay, all right. Oh, I have a clock right back there. All right, so what were their resources? Well, they had a number of different resources. I've given you an image right here of a book written by Edward Corwin, a famous political scientist, called The President, Office and Powers. In 1948, just before the seizure, it was already in its third edition. Corwin was a political scientist. This book really sets out a vision of the authority of the presidency that is suited to conducting World War II. He read John Locke to argue that the executive power the Constitution conferred on the Congress contained within it a kind of discretion to violate the law if it was necessary for the public good. Okay, so there were some theoretical sources for finding in favor of the president, but this is just theory. It's not doctrine. What doctrine was there? There wasn't a lot. There wasn't a lot. There were a handful of cases in foreign policy and a handful of lines of cases in domestic policy. In foreign policy, the most pro-presidential case was a case called United States versus Curtis Wright. Okay? United States versus Curtis Wright concerned whether or not Congress could delegate to the president an authority to decide that U.S. Arms manufacturers couldn't sell their products overseas because of a dangerous armed conflict. Curtis Wright, of course, was a Buffalo manufacturer of warplanes, and they brought suit against the statute that allowed the president to forbid them from selling warplanes, in this case to South America. Justice Sutherland, in deciding Curtis Wright, says the powers to declare and wage war, to conclude peace and make treaties, to maintain diplomatic relations with other sovereignties, if they had never been mentioned in the Constitution, they would have been vested in the federal government as necessary concomitants of nationality. This is the idea of some kind of inherent power. It's not really based in the Constitution. It's just implied by the fact that the federal government is sovereign. So there was this authority in the area of foreign policy, but again, the context wasn't war, right? The context was a time of peace. What about domestic policy? Here is a table of contents from a 1950 constitutional law casebook that I had on my shelf. It's written by Frank Strong. It's called American Constitutional Law. You can't see what the table of contents says, but I'll tell you its significance. What there wasn't when the justices were trying to decide this conflict between the president and the Congress, what there was not was a general doctrine of separation of powers. A general doctrine that told the court how to resolve contests between Congress and the president when Congress has spelled out some kind of method or approach that they want the president to follow, and the president has deliberately not followed it. There was no such doctrine. There was something called non-delegation doctrine. Non-delegation doctrine was this idea that Congress can't give away its legislative power. And that was a kind of separation of powers doctrine because it forbade the president from exercising legislative power. But if you see from this casebook, this is really surprising if you've opened up a contemporary casebook. Every common law casebook will have a chapter on separation of powers. This one doesn't even have it. Professor Strong calls the part methodological limitations on governmental power over economic and civil affairs, and separation of powers is called merger of governmental function. Merger of governmental function. It doesn't have the title we even give it today. Non-delegation doctrine then is called delegational merger. Okay? So the court simply does not have a doctrinal tool it can apply. There are other doctrines and ideas as well, but none that had direct application. So what did the court do? The reason we have so many opinions, one of the reasons we have so many opinions in this case is because the court was, in essence, the people who voted in favor of upholding the injunction, the judges were trying to craft a separation of powers doctrine that didn't yet exist. And they were drawing on theoretical sources, and they were drawing on the bits and pieces of ideas in different judicial doctrines that were there. But it's not surprising that they could only get votes for themselves, because how each of them tried to put the doctrine together differed. The opinions are traditionally distinguished in law school. The opinions in favor of the majority are distinguished between formalism and functionalism. Here are the formalists, Justices Black and Douglas. Justice Black, as I mentioned earlier, wrote the opinion for the court. He basically argues that the president, in seizing the steel mills, was exercising legislative power, since he was deciding on a presidential policy to be executed in the way he thought appropriate. Okay? That's an exercise of presidential power. He's really drawing on the non-delegation doctrine there, which defines legislative power formally as the power to make laws, to set up rules that are then going to be followed. Justice Douglas follows him in an opinion that draws on the same basic ideas. Frankfurter here is labeled as a functionalist because his opinion rejects that basic assumption. Frankfurter had been a law professor before he went on to the court and was in particular involved in the early conceptualization of the administrative state. And he knew that Douglas's and Black's portrait of legislative power just wasn't accurate. A lot of the time, the executive branch was coming up with the rules. The administrative agencies were deciding how broad policies passed by Congress were to be given effect. So Frankfurter said, the different branches are not formally separate. They are separate but interdependent. They're not wholly disjointed. That's Frankfurter's idea. In this particular case, however, what the president has done violates the separation of powers because Congress had already weighed in and said that he had to follow a particular method laid out in the Taft-Hartley Act for doing the seizure, and the president didn't follow that method. To allow the president simply to ignore Congress would be to upset the balance of power. That's Frankfurter. Now, you can't see all this language, but this is Jackson basically parroting Frankfurter. So a large part of Jackson's concurrence is basically Frankfurter's theory of separation of powers, but it's expressed with Jackson's eloquence, which is why I've quoted the language here. He says the actual art, this is Jackson now in his concurrence, just invoking Frankfurter, the actual art of governing under our Constitution does not and cannot conform to judicial definitions of power of any of its branches based on isolated clauses or even single articles torn from context. This is an important thing because we see the court do this a lot today. You can't simply say legislative power is this, looking it up in Black's Law Dictionary. That's not how government works. That's just not how things get done. While the Constitution diffuses power the better to secure liberty, Jackson says, it also contemplates that practice will integrate the dispersed powers into a workable government. Very Frankfurter. The point is to have a government that works. That means that the legislature will often hand off to the executive branch an authority, essentially, to make law. Why do we allow that? Because the Constitution is aimed to create a government that can solve problems. It's supposed to work, okay? So the branches are separate but interdependent, paraphrasing the last bit of the language. They're autonomous but reciprocal, okay? That's Jackson. That language is very famous. We'll see that it gets used later, but it's essentially Frankfurtian. Here's Jackson's contribution. What Frankfurter didn't want to give was a general theory of how the branches actually should work. Frankfurter was kind of a minimalist. He was afraid of the court exercising too much power, so he confined his remarks to the specific circumstances before the court. Jackson was much more willing to give us a general theory. This is absolutely central for the thesis I'm going to defend today. His general theory is not limited to the particular case before the court. What he's going to argue is you can figure out what the Constitution says about the president's relationship to Congress based on the sequence of governmental action. Okay? Now, he was drawing, historians have shown that he was drawing on opinions by a district judge named Augustus Hand, but Jackson really gives us his own formulation. Here is how sequence affects authority. This is the most famous part of the Jackson concurrence. Some of you may be familiar with it already. There's 3 categories, Jackson says. First, in the first category, Congress acts first and authorizes the president to act. In that case, the president is acting, Jackson says, with the full measure of authority of the federal government, and the court should essentially defer, right? The president only lacks power if the whole national government lacks power. That's the first category. Second category is Congress is silent, doesn't do anything, essentially inviting the president to take initiative. So the president acts first. In that case, you have to look at Article 2 to see if the president has an independent source of authority. Last sequence, and the crucial one for that case, was when Congress acts first, prohibits what the president does, then it is the court's job to scrutinize what the president has done quite carefully. Because the president can only act if his independent authority extends beyond what Congress can say. This is Jackson's theory. This is not based on the case. Okay? Some people might complain that he has no authority to do this. He's just giving you a general theory of how government works based on his experience as AG and reading an opinion by Gus Hand. Okay? How does Jackson handle Holmes-Baldridge's argument that the president has to have an inherent power to do what's necessary to meet an emergency? He says it's inconsistent with a notion he calls free government. And here he quotes the Rudyard Kipling He says, the essence of our free government is leave to live by no man's leave underneath the law. That's a quotation from a Kipling poem. What does it mean? According to Jackson, it means that the essence of free government is to be governed by those impersonal forces which we call law. But the executive action here originates in the individual will of the president and represents an exercise of authority without law. Okay? The job of the court is to uphold acting under the law. That's why there can't be any inherent power simply to do what's necessary to meet an emergency. That's the life, okay? That's part one. We looked at the factual background of the case. We considered the doctrinal and theoretical resources that the court had to solve the problem in front of it. And we looked at the way the court resolved it. Different justices resolved it. The big difference is not just between Justice Black and Justice Frankfurter and Jackson, formalism and functionalism. That's the way they teach it in most law schools. It's also between Frankfurter's minimalism and Jackson's expansive theorizing. Right? So just keep that in mind as we talk about Afterlife. Decision was immensely popular. Here's the New York Times legal journalist Arthur Crock writing just days after the decision came out. He writes in this op-ed that the opinion of the court is one of the most popular in its history. Okay? Now, how he knows that, writing just a few days after, I don't know. But part of it had to do with what the public was perceiving was at issue. The public saw, again, not a war emergency, but a president confiscating private property in a lawless way against what Congress required. So it was popular to tell the president that even he had to follow the law, and it was popular for the court to defend private property. The decision, the opinions were celebrated in Congress as well. We have legislative history from the floor of Congress. People are celebrating the Supreme Court's, congressmen are celebrating the Supreme Court's decision. No one thought the Supreme Court would weigh in on the behalf of Congress against the president. There was some criticism. This is a kind of random thing I found. I was looking at Casebooks trying to get a sense of how people perceived and understood the Steel Seizure case, and I found this article from Deutsche Zeitung, just folded into an old casebook that I'd bought online. This is kind of like, if you're a legal historian, you're just, you know. And my German is just good enough to read the article, and basically what the article is faulting the Supreme Court for is having too many opinions. Chief Justice Vinson was supposed to be this great compromise artist, but instead we have a decision with 7 opinions. Vinson is writing a dissent in which his views presidential power is, according to the author of this op-ed, without any real foundation. Professor Paul Freund, writing in the Harvard Law Review, makes essentially the same argument. Maybe this was Professor Paul Freund's book, I don't know. He says that there are too many opinions, the court can't serve its coordinating function if there are. Another criticism comes from this guy. Anyone know who this is? Very famous visage. This is a Court of Appeals judge who's one of those judges that everyone regards as one of the most talented in American history but never was on the Supreme Court. Learned Hand, have you heard that name? Okay, Learned Hand, Augustus Hand's brother. Okay, so Augustus Hand was the judge that wrote the opinion that Jackson used for the 3 categories. Learned Hand was his brother and had an active correspondence with Felix Frankfurter. This isn't the letter that I am interested in particular, but it's one in a stream, and it was one I could get a digital image of online. Learned Hand writes to Felix Frankfurter and criticizes him for upholding the district court's injunction against the seizure. And why? Well, because according to Learned Hand, it was not a place for judges. It was not a role for judges to step in on the side of Congress against the president. That was really a political matter. They should resolve that using political tools. It was not a place for the court. Okay? And that was a criticism you sometimes see. You hear that today, too. You hear that from progressive scholars who think the Supreme Court should essentially not resolve separation of powers disputes. They should just dismiss them. Let them be politically resolved. Learned Hand is making that argument to Felix Frankfurter. So, When did this set of reactions change? Jackson doesn't yet figure in any public commentary, right? His opinion is just one of 7. People are focused on the black majority. They're celebrating it. There's some criticism that there were so many opinions. But this is not the Steele seizure case we know now. I posed this question to John Barrett, who a bunch of you know very well, and he pushed me in the direction of Gerard Maglioka, who's a legal historian at Indiana University. And I got Maglioka on the phone, and he said this changed with Nixon. He said it was the Nixon administration that was really responsible for elevating the status of the Jackson concurrence. Here we have a newspaper report on the passage of the War Powers Resolution. What was the War Powers Resolution? Well, it was Congress's response to Nixon's decision to expand the war in Vietnam into Cambodia, which was immensely unpopular. Okay? When Congress started signaling that it might defund the war to prevent President Nixon from expanding it like that, Nixon's attorneys in the White House had a conniption fit. And we have memos in which they're describing what they perceive to be an unprecedented attack on presidential power. Okay? So Congress needed some kind of authority it could rely on in resisting unilateral presidential war making. When it passes the War Powers Resolution, which is basically a regulation of the president's power to initiate armed conflict under the Commander-in-Chief Clause, on the floor of both the House and the Senate, they are quoting Justice Jackson. They're quoting Justice Jackson's discussion of the nature of Commander-in-Chief power in the Youngstown concurrence. So suddenly it pops up. Why does it pop up? I asked Maglioka, why are they quoting Jackson? Is it because of something he said? He said, it's just because it was more quotable. Okay? All right? Then we come to Watergate. This is an image of transcripts of the Watergate tapes. Watergate, from a presidential power perspective, was essentially a struggle over information. Okay? The basic setup is it's discovered that President Nixon had taped conversations in the Oval Office that might be relevant to an ongoing grand jury investigation into the burglary, right? And so the special prosecutor conducting that grand jury session subpoenas production of the tapes, right? I mean, a lot of this sounds very familiar, right? Okay, so he subpoenas production of the tapes. And in response to the subpoena, the Nixon attorneys show up in district court and say, this would fundamentally impair the government of the United States because it would put the president under the direction of a district judge and a prosecutor, making Article 2, that's the article that deals with the president, subservient to Article 3. Okay? The special prosecutor was this guy, Archibald Cox, professor of law at Harvard University. And so he needs a response to this argument. So he starts conducting extensive research on the history of presidential assertions of privilege from subpoenas, both from courts and from Congress. And what he finds is that over the long term, presidents had not claimed a privilege to be immune from requests for information simply because they were having confidential discussions. There had to be a risk to a particular person. Cox is apparently looking for a pithy way to summarize his historical research. And who does he stumble upon? He stumbles upon Jackson. He uses Jackson to describe why the White House's view of presidential power is wrong. Your Honor, Cox says, in pleadings before the district judge, before the district court, the Constitution doesn't require formal separation between the branches. Now remember, that was what Justice Black had said in the majority opinion in Steele Seizure. It doesn't require that. Here's my evidence. He picks up a concurrence with one vote behind it. Right, but well written. He says, and then he just uses basically Jackson's language describing how the branches work together, okay, which is essentially a Frankfurter theory. And the judge, Judge Sirica, likes it. And so he includes it in his first opinion, allowing for the subpoenas to go forward. The litigation bubbles up to the Supreme Court. And in the case of United States versus Nixon, the Chief Justice Berger uses the same language from Jackson. Suddenly, in a majority opinion of the Supreme Court, Jackson's concurrence is there. Any word about black? No. Why not? It didn't help them resolve this problem. Had nothing to do with this problem. Now, you know what happened to Archibald Cox, right? He got fired in the Saturday Night Massacre, right? Nixon ordered him fired. The Attorney General and the Assistant Attorney General refused to do it and resigned. And then another Assistant Attorney General, Robert Bork, did it. So it's not really a story about Cox. It's a story about people behind Cox and other people realizing the utility of this idea. Here's another guy that's relevant. You know who this is? This was... Why is that funny? This is Cox's research assistant from June 1972. Do you know who that is, though? This is my dad. I don't know that he worked on that litigation, but I do know that he was Cox's research assistant, which is kind of a cool connection. It also shows how these things involved more people than the Supreme Court. It wasn't just Cox, it wasn't just my dad. It shows up again in Congress after the Watergate controversy. Another statute, the Presidential Recordings Act, passed by Congress in an effort to prevent Nixon from destroying the tapes after the presidency, also sound relevant? Okay? On the floor of the Congress, they're citing Jackson again. Okay? Another one in which they use Justice Jackson is the National Emergencies Act, which is a regulation of the presidential power to declare emergencies. Here's Senator Church. Notice what, you can't read the text, I'm sorry, but what he's quoting here is not the Frankfurter part of Jackson's opinion, it's the three categories, the three sequences of congressional presidential action. That theory that Jackson just made up is being cited on the floor of Congress in an effort to regulate the power of the president to declare a national emergency. Why? Because it was useful and seemed to make sense, and because it was gorgeously written. Right? Okay? Oh. Sometimes Jackson's concurrence is criticized as being pro-Congress. For a while, people regarded it as a defense of congressional supremacy. Basically, Jackson says, Congress goes first, it authorizes the president, then the president can act, but if it says the president can't do it, essentially the president loses the authority to act. Chief Justice Rehnquist, whom I think probably a lot of you know, was Jackson's clerk. The term that the Steele seizure case was decided, applied the Jackson concurrence, that particular part of it, that's here, the three categories, in a case in 1981 called Dames and Moore versus Reagan, showing that you could actually sustain presidential power by using the concurrence. In that case, Rehnquist used the Jackson concurrence to sustain President Carter's nullification of the judicial attachment of Iranian property as a way to end the hostage crisis in Iran. Okay? That same term, here is clerks. Do you want to know who this is? John Roberts. Okay? This is an interesting connection of people. So by the time of 1981, when John Roberts, our current Chief Justice, is clerking on the court for then Associate Justice Rehnquist, the Jackson concurrence had gone from being the theory of a single man and a concurrence that got one vote to being incorporated into a majority opinion of the court. And Rehnquist introduces it by saying, the most sense we have in this area is given by Jackson in his concurrence, and then basically quotes it. So it had become the law of the land in the court as well. This is a split screen of the White House and the Congress. Patricia Belia, whose research I mentioned earlier, says the way to read the Jackson concurrence really is as being addressed to people off the court, and in particular to the executive branch and to the legislature. To the legislature, Jackson was saying, don't wait. Don't give in to inertia. Act. And that way you can control the use of presidential power. To the president, Jackson was saying, get good advice, be prudent. Yes, you may have some kind of emergency power, but don't assert it in a way that brings you into court, okay? Because a court is going to need to test its boundaries, right? It was addressed to other branches, so other branches could make use of it. Thus, the authority of the opinion would blend with the authority of those branches. That's life and afterlife. That's the opinion and how the opinion was made use of. Here's the last slide, and then I'll let you go. This is Jackson testifying in the Senate in 1937. You can't read the text, maybe you can, but the testimony is on the subject of court packing. Everyone know what that is? FDR proposed packing the court to prevent the Supreme Court from striking down the New Deal. Jackson shows up and supports the court packing plan. Well, like, you know, a good executive branch attorney. But his argument is that the problem with the Supreme Court is that it's too out of touch with popular opinion, which I think is directly relevant to the path the Steele seizure concurrence takes that we've shown today. Okay, how does the Supreme Court's opinion get popular authority? Not simply by resting on the authority of the Supreme Court, which doesn't really have any democratic credentials, right? It's appointed by the president for the lifetime of the justices. It gets popular authority by being used by other people off the court, both in government and outside of government. Legal historian Willard Hurst said, the job of the Supreme Court in separation of powers cases is to give us ideas and symbols with which we can do our politics. Right? And you see the concurrence doing just that in the Nixon administration. It played the same role in the War on Terror, and it's played the same role more recently as well. Okay? That's the role of the Supreme Court. And it's a democratic role. Why? Well, because when the words get used, they're not even really Jackson's anymore. They're the words of the people making use of them, right? They're our words. If they get repeated and invoked, incorporated into our decisions, they become ours. They rest on our authority, which is popular authority. Okay, that's my remarks. Thank you. I'm happy to take questions if you have questions. I forgot your name.
Does this relate to executive branch people ignoring congressional subpoenas?
It does. It does relate. Now, there's a separate body of law governing whether or not the executive branch has to respond to a congressional subpoena and the limits of that power, than whether or not the executive branch has to respond to judicial subpoenas and the limits of that power. But the general framework for deciding both cases basically comes from the Nixon era and derives from comments in Jackson's concurrence. And the general framework is this, that when Congress is investigating and issues a subpoena into the executive branch cannot refuse if it would undermine the essential function of Congress. That essential function is legislating. So a subpoena is supposed to be connected in some way to Congress's power to pass laws or to supervise how the laws they have passed are being administered. Equally, Congress cannot subpoena when answering the subpoena would fundamentally impair the operation of the executive branch. Notice how the test works. There is no formal separation between the executive branch and Congress. They interact. Congress can demand things of the president. What Congress cannot do is prevent the president from doing what the Constitution requires the president to do. So there is a limit. Recently, the presidents have been more aggressive in refusing to honor congressional subpoenas. Now, the Supreme Court has in some ways upheld Congress's power. But in other ways, they've refused to get behind forcing answers to those subpoenas. So they won't throw people in jail for contempt necessarily, but they do say that Congress has that power. So yes, Jackson is at the absolute center of those debates. Greg.
By the way, you need to know this was a master class you just observed in incredible constitutional law. Thank you for sharing this. A lot of new stuff. In your research, and I know you took a sabbatical off to do a lot of this research, what was the surprise you came across? Did you walk in with a theory, term, an idea, just find the evidence that support it? But there had to have been a knuckleball and all that.
Well, the surprise was, a couple of things. I was surprised at how little the court had to go on to resolve the dispute in the Steele seizure case. They really were writing on a blank slate. I looked back at all the old textbooks and tried to put myself in the mind of a con law teacher from 1950, and all of the basic things we assume and teach today just weren't there. I was surprised at how much Jackson took from Frankfurter. A lot of things we credit Jackson with really are ultimately, if not derived from Frankfurter, highly influenced by Frankfurter. The other fun thing is just the personal connections through all of this. The weird fact that Rehnquist was Jackson's clerk and Chief Justice Roberts was Rehnquist's clerk.
And your dad was a research clerk.
Yeah, so my dad passed away just before COVID, and he had dementia, and so I never really got to plumb his memory about what he had done for Cox. I visited Harvard Law School with him when I was in high school, and he took me into one of the buildings, maybe Ames, and he described having class with Cox in that building, and at the time the way it worked was when you were called on, you had to stand up, and the drama of it was still with him. Cox was famous then because he'd been part of the Pentagon Papers litigation as well. And so being able to be Cox's research assistant as well as having a class with him, that was a huge deal for my dad. So, yeah, it's a fun connection. Yes?
I'm confused about a timeline
Sure.
dealing with the Korean War. At the beginning of your presentation, I thought you said that the demand for steel and the resulting inflation of the cost of steel had to do partly with the demand for war materials.
That's my understanding.
But then the rest of your presentation dealt with this, that this was a peace issue, that we were not at war.
Great question. Great question. There's always one student who listens extremely carefully. So there are a couple things going on there. One is that my characterization of it as a peace issue is in part a characterization of public perception. The other thing about Korea, if you recall, is that it was not a declared war. It was what Truman called a police action. Of course, it was a war in effect and a war in substance. But it didn't have the formal legal sanction of Congress's use of the Declare War Clause. It only could be backed by Congress's appropriation of money in support of the president's police action. So legally, it wasn't a war. And in popular perception, according to Maeva Marcus, the legal historian, whose work I relied on tremendously, people just didn't see it as a kind of wartime exigency. You know, steel was being used for all sorts of things, and it didn't seem to be in short supply. The prices were high, but they were being controlled by federal administrative agencies. So, yeah, that answers it. Anything else?
On the War Powers Act, that seems to be forgotten a lot, that the president can order troops into Syria or troops into whatever, into various conflicts.
Yes.
And so isn't that presidential power against the War Powers Act?
No, the way the War Powers Act or the War Powers Resolution is set up is that the language of the act in effect acknowledges that the president will introduce the armed forces into conflict without congressional sanction. It then requires the president to report to Congress on what he or she has done, and then if there's no declaration of war or congressional support, after 60 days to withdraw. This timetable came up during Obama's presidency with the action in Libya. So there was an accusation that President Obama had refused to comply with the withdrawal timetable. Secretary of State Harold Koh, who was the former dean of Yale Law School, came into Congress and testified that there was in fact a level of armed conflict below the hostilities defined in the War Powers Act. Think of something like the action that happened just a couple days ago where the leader of ISIS was killed. So there are some kinds of humanitarian missions or commando rescue missions. There are some kinds of presidential initialized rescue missions, assassinations that aren't subject to the War Powers Act. But then there are presidential initialized armed conflict that is subject to that reporting and withdrawal timetable. And then there's war, which is supposed to be a step beyond and require congressional initiation.
But these go beyond the 60 days.
Yeah, well, so in the case of a war, Congress authorizes it by using the declare war clause.
No, but we haven't had a war declared since declaration of war, right?
Well, it depends on what you count as a declaration of war. Like Gulf of Tonkin resolution might be a declaration of war.
Oh, okay.
The AUMF that authorized the war in Iraq might be a declaration of war. Right? That stayed in authority for how long and continued to authorize operations in Pakistan and Afghanistan that had nothing to do with Iraq. So the words declare war might not be required. Just not entirely clear.
The Bay of Pigs, is that called the victims administration?
The Bay of Pigs, that's not part of my research. So I don't see people invoking it with the Bay of Pigs crisis, Bay of Pigs invasion. Anything else? Thank you so much. It was such a pleasure to be here. These guys are from St. Bonaventure, and I know the professor because I gave a talk at St. Bonaventure this fall.
Oh, cool, cool. I just want to get